listening to the various interventions, what went around my mind was the provisions of Article 119 of the Constitution about when members of public present petitions to Parliament. It says that Article 119, a member of Parliament, any person may petition Parliament on any matter that it has authority. So, and I'm saying this with a lot of respect because I've seen a situation whereby I think some matters which have been brought to Parliament, they are not for Parliament, but it's just one of those things that I say there's a lot of latitude people to to take things where they don't belong. Mr. Chairman, and you said it, we are the state law office. Our only client is the government of the Republic of Kenya. So various state departments, agencies of government, sometimes county governments and constitutional commissions do seek our services. So, and I'm saying this because many of the questions would have to be directed to our client, the State Department of Housing, working in conjunction with the National Treasury. Some of these ones are the issues to do with the one that the Honorable McClub raised about the 1%, the issue of the gross and net, and all those would have to be taken to the instructing client, because it is the instructing client dealing with the issues of operations who should deal with that. If they instruct us that we propose that it will be 2.5% for us, it will be wrong for us to propose a different figure, because they are the ones who have worked on those figures, and the ones who are, our business is to make sure that it is crafted in a language that makes sense. As to operations, it is those ministries that who can respond adequately. And I'm saying this because as we finished our meeting yesterday, I think I got indication that the responsible cabinet secretary was indicating that she was going to appear before the committee to shed light on this, and I believe she will be coming. When she comes, she will be coming with those people in the housing department, state department, alongside the National Treasury, because some of these I think are debatable, and I think the state law office would be remiss in trying to delve into this, because we may not have the necessary competence. There's the issue of, course, there's an issue raised by Honorable Mwaliko. The first one was whether we were involved, and I think Mr. Honorable Rico also raised it. Maybe so that, because I don't do drafting, and I have a senior drafter here. And when I was in Parliament, actually almost exclusively the draft people who are in the legal department of Parliament came from the AG's office. Now that we still have some, why don't I just get in, you hear it from the horse's mouth whether they were involved. So much. Clause 2 further defines a collector as the Kenya Revenue Authority or any other person appointed as such by the Cabinet Secretary for the National Treasury, so that the perceived inconsistency by in the law, in the Finance Act, wherein the Cabinet Secretary for Lands is the one that was giving authority to the KRA, has now been remedied by this provision. To this end, we have the view that the draft bill comprehensively addresses all the three issues raised by the Honorable Court. But again, Mr. Chairman, as I said, these are proposals. The bill before the House is a proposal, and the House is at liberty to clean it up, make further and or other provisions as the House may deem appropriate. third issue was on the existence of the Housing Fund and the structures under the Housing Act, and whether there will be potential overlap, stroke duplication of functions with the enactment of the bill. On this one, Mr. Chairman, I note that the objective of the Housing Act is to provide for loans and grants of public monies for the construction of dwellings. In order to achieve this objective, the Act establishes the National Housing Corporation, funded through the National Housing Development Fund. On the other hand, the Affordable Housing Bill's objective is to provide a legal framework and a funding model in provision of affordable housing to Kenyans. We note, Mr. Chairman, that the Act and the bill complement each other through a structured way of giving effect to Article 43, Clause 1, Paragraph B of the Constitution, provides that every person has a right to access adequate housing and to reasonable standards of sanitation. Complementary. Nevertheless, Mr. Chairman, Section 7, Subsection 3 of the Housing Act does not provide for the source of funds of the National Housing Development Fund to include allocations from the Affordable Housing Fund. This would require consequential amendments to the Housing Act, in our view, Mr. Chairman, so that, in our view, there is no overlap and there is no duplication. But should it be required, should it become necessary, Mr. Chairman, that some of the funds from the housing, affordable housing, can go to the housing, National Housing Development Fund, then that would have to occasion an amendment to the Housing Act to allow for that. Otherwise, as it is now, the funds under this levy cannot go to the National Housing Development Fund. So there's no overlap. Fourth question, Mr. Chairman, is whether the bill aligns with the Public Finance Management Act of 2012 with respect to the establishment of the levy and the fund, which is where I was making the distinction. Mr. Chairman, we all know that under the PFM Act 2012, under Section 24, Subsection 4 of that Act, it's only the Cabinet Secretary for the National Treasury who may establish a national government public fund with the approval, again, of the National Assembly. Further to Subsection 4, Subsection 12 recognizes that a public fund may also be established through an Act of Parliament by providing that this section shall apply to all other national public funds, including funds earmarked for specific purposes established by an Act of Parliament. And to give an example of this, Mr. Chairman, is the Roads Fund under the Kenya Roads Act. There's one such fund. Indeed, Mr. Chairman, there is one that I know we created here, called the mortgage fund, parliamentary mortgage fund, the car loans fund of Parliament. They are all created under different. Those ones are created under the Parliamentary Service Act. So this is what, in terms of what is provided for in subsection 12 of section 24 of the PFM Act. The salient principle that needs to be adhered to when establishing a public fund under the PFM Act or any other act is to ensure that mechanisms and structures are put in place to effect the prudent usage of the public funds in accordance with the Constitution. The bill, in this respect, proposes to establish the management board responsible for inter alia managing the fund and allocating monies as envisaged under Clause 11. Further, the bill proposes to designate the Chief Executive Officer appointed under Clause 12 as the accounting officer of the fund in line with Section 24, Subsection 10 of the PFM Act. To this end, we are of the opinion that the establishment of the Affordable Housing Fund is within the meaning of the Public Finance Management Act, and that's a question that was raised in question 4. However, it is prudent to note that the provisions of Section 6, paragraph F of the PFM Act requires that where there is inconsistency with any other act of Parliament establishing a fund, the provisions of the PFM Act shall prevail. They take preference. It's important to note that, so that even in the event that any provisions within this bill may appear to contradict anything that is in the PFM Act, the provisions of the PFM Act will prevail. And I think for good measure, because I think the PFM Act, if you read the Constitution, is that act which is anchored in Chapter 12, which is a chapter on public finance in the Constitution. Finally, Mr. Chairman, you sought our view on the fact that the bill is silent on the procedures for the transfer of public land on which the affordable housing projects are built. And the question you asked is, how does the State Law Office propose to deal with this legal gap in the bill? Mr. Chairman, the State Law does not intend to deal with this. Our reaction to this is just to explain the salient features of both the Constitution and the Land Act. Article 67, Clause 2 of the Constitution provides that one of the mandates of the National Land Commission is to manage public land on behalf of the national and county governments. Further, Article 68, Paragraph C, Paragraph Roman 2 of the Constitution provides that Parliament shall enact legislation providing for the manner in which any land may be converted from one category to another. And this is important because if it is public land and it is designed, particularly in the context of this affordable housing, then the National Land Commission will be involved either by the national government, if the land belongs to the national government, or the county government, each county government, if the public land belongs to the specific county government, so as to convert from public into private use. The mechanism already exists. Article 62, Clause 4 of the Constitution provides that public land shall not be disposed of or otherwise used except in terms of an act of Parliament specifying the nature and terms of that disposal or use. On this premise, the Land Act was enacted by Parliament in 2012 to clearly provide for the mechanism to be applied. In fact, Mr. Chairman, I was surprised when I saw somebody crying that they have not been involved, because it's just the county governments and the national government who are supposed to go back to the provisions of the Land Act and involve the National Land Commission in acquisition of land and conversion of it from public to private. In fact, Section 9 of the Land Act provides that any land may be converted from one category to another in accordance with the provisions of the Act or any other written law, and that public land may be converted to private land by allocation. So the provision already exists in the law. Further, subsection 5 of that Section 9 provides that the National Land Commission may make rules that may provide for the substantial transactions requiring approval of the National Assembly, as the case may be, if it is land belonging to the national government, or the county assembly, regulating and controlling the conversion of land from one category to another, and the factors to be applied or taken into account in determining land that is to be converted, amongst others. In addition, Part 3 of the Land Act provides for elaborate procedures for the administration of public land, including leases, licensing, covenants, and conditions of leases and licenses, the buildings developed on public land, amongst others. Therefore, the provisions for the management of affordable housing units developed on public land, whether county or national land, are adequately provided for in the Land Act and need not be replicated in the Affordable Housing Bill, Mr. Chairman. I beg to submit.
Thank you. And before we proceed, maybe some members who are online wanted to introduce themselves.
Involved in the drafting of the finance bill, and that's what he has confirmed. Remember, Parliament was involved in passing the finance bill into Act, but the court, in performance of its functions under Article 165 of interpreting the laws, found some sections of the Finance Act as unconstitutional. It is not. It's not strange. It's not even unique to Kenya. It is the which. In fact, it should be. It should be that way. That we take instructions from the state departments. They tell us this is what we want. We tell them it can only be fashioned in this way. Then it comes to Parliament. Parliament will also. Parliament, of course, makes a lot of amendments. In fact, it is in Parliament where there are a lot of amendments, which is very. It's a very healthy democratic practice. Once it has been passed by Parliament, it is now left to the judiciary to interpret it. So if the judiciary finds something untoward in an act of Parliament, it is perfectly within their power to interpret and make the statement. But remember, whatever it is they do, they will not make the law. Whatever it is the executive may do, they will not make the law. Law is an exclusive function of Parliament under Article 94.
Chair.
In the process of making law, second reading of any bill is a very good, very good stage. But remember, beyond that one, you have to go to when you go to committee of the whole house. Please, it is within your power, which cannot be taken away by anybody, to propose amendments. And now it would have been very good that Honorable Ariko would be saying, I even proposed an amendment which was defeated, but I was proved right by the court. But if you just spoke about it in committee and in second reading and never proposed an amendment, once it is passed,
Order, Attorney General. You are now acting as a speaker. You are coming back to yourself.
He was still very new. He did not know the procedure. Maybe next time he's going to propose it.
Thank you. But I think it's nevertheless still a valid point that indeed the state law office should at all times be involved in the drafting of any legislation that comes to Parliament. Even though Parliament is still the legal department, but the legal department can only do so much. And I think some of the staff who have introduced themselves here are in the legal department. And I think Honorable Ariko spoke with regard to the provisions of paragraph 8, isn't it? On the apparent overlap, which I had addressed. Paragraph 8. Paragraph 8 of whether this bill takes the interest of each and every Kenyan. It would be very difficult if we are not invested with the wherewithal to make that kind of economic determination, because again, the State Department that originates the bill should be the one to say. And it's not very easy to come up with something that incorporates the interests of each and every Kenyan. But I believe what they have done is to try as much as possible to try and capture the interests of as many Kenyans as possible. I do agree, however, that some of the observations made by the members, including the Honorable Njoki, that there are some of the people, because of how much they earn today, who may never be able to raise sufficient money to amount to a deposit as to qualify to get these houses. But I think, again, that's a matter that, since the bill is before the House, is a matter that the committee is at liberty to make proposals, amend as appropriate, because lawmaking, again, as I said, is within your powers. It's in your hands. Honorable Onyoro, again, whether we could take the parameters that that are used within the national government CDF alongside similar alongside this the proposals in this bill, again, it's a matter that would go to the State Department originating the bill. And I think I was assuming, Mr. Chairman, by now the very passionate principal secretary in that State Department has appeared before you and persuaded you in this. Because that I think is committee.
He has appeared before this committee and he has done his part. Now, members, stop casting aspersions on anybody. Please proceed.
And I think, Mr. Chairman, the point you raised also as the model similar to the NSF is also a good proposal. I would just say, well, this bill is actually, it's your report. Now, where it goes, or if it becomes law, it will become law on the basis of the recommendations that are going to come out of this committee. And I think, the chairman, I see the committee very well represented, and I'm sure you will act in the best interest of the country, make propositions that reflect the best interests of the public, or at least the majority of the public of Kenya. There was an issue raised, is this by Honorable, who raised the issue of the possibility of one person, because of what the provisions of clause 33. Is this McLeod? Yes, Honorable McLeod. Actually, this is a real possibility. I've actually myself thought about it. But, well, listening to those that are dealing with operations, they seem to suggest that the system that is going to be put in place is one that will make it impossible for one person to acquire more than one of the houses. Although, again, that's a matter that if we are going that route, it's a matter that I think you need to tighten all the loose ends, that to avoid a situation whereby one person using several other people could purchase 10, 20 houses and maybe even allow those people to live there on some arrangement. This is possible. It is possible. I want to agree with you, Honorable McLeod. It is possible that can happen when we have this situation where we say they can surrender or can whatever transfer. It is possible, but again, because it has not become law, it is within the power of the Honorable McLeod to make sure that such an eventuality does not see the light of day. Thank you.
Speaker, again,
so that then, when an institution is allocated part of these funds, then there must be a mechanism. A mechanism must be inbuilt to ensure that the interest, the overarching interest of the bill is not defeated. It will go to operations. So again, Mr. Chairman, I'm still just implore on the committee to be able to tighten up in your report and in making appropriate amendments to that to avoid a situation whereby the fund can be misused.
I think, Chair, I think that's correct, because in the committee during public participation of the Finance Bill 2023. And I specifically raised this matter on the infrastructure, on the basis of levying Kenyans this money. There was no legal framework for levying the funds, for levying this tax on the Kenyan citizens. This matter was under public participation. We raised it. I thought it was taken care of. And I say it will be challenged in Parliament, and if Parliament will not challenge this matter will be challenged by the courts or by Kenyan citizens through the courts. And this matter is taking us back to the drawing board. And that's why we are going around to bring this legal framework to implement this particular levy. So, and that's why I say the office of the AG has to be fully involved to support us in coming up with these bills or legislation to support the government. Otherwise, we'll be repeating ourselves. Thank you, Chair.
Thank you, Mheshimiwa Rico.
That's a good
Chairman, it is now apparently clear that this matter will have to proceed to Senate because of the functionality of the Constitution of the fourth schedule.
Mheshimiwa Makilap.
So,
observations.
Chairman, we continue to require, because Chairman, we went through public participation, and the public are saying, how do you keep a public land in Baringo, for example, to be constructed affordable housing, and in the long run, that land goes to a private person? So these are the issues that the AG, because of their clarity of thought and law, will continue to, help the state departments that you take to operationalize this process properly, so that we don't want a matter that when we pass in Parliament, it again brings litigation and we come back here, Mr. Chairman.
Thank you, Mheshimiwa Makilap.
Chairman, we are here to